Hi, and thank you for contacting Barcena Law Offices regarding your consular process. For the consular process, what usually has to happen is first we start with what's called a family petition. This is an I-130, and it is the U.S. citizen sending an application to USCIS, which is the United States Immigration and Citizenship Services, saying, I'm a U.S. citizen and I would like for my spouse to be able to apply for residency one day. Now, the reason that someone would have to do the consular process is because they did not enter the United States legally. In order for someone to do what's called an adjustment of status, and that's adjust from one status to the other, they have to have entered legally or have some other grounds of doing that. In a case where someone entered unlawfully and never got any other type of way to get a legal entry, such as advanced parole, military parole in place, or had that legal entry, or what's called 245I, filing a petition before April of 2001, then we have to do the consular process. So after we do what's called the family petition, so that's the U.S. citizen spouse submitting a request, and the relationship is proven to be valid, so it's a real marriage. Then what happens is the case gets sent to the National Visa Center. So once the case is sent from the USCIS to the National Visa Center, it takes about 30 to 45 days. You have to be on the lookout for an email. Sometimes they forget to send the email, so if they don't send an email within 45 days, you have to contact them through the public inquiry using your receipt number from the USCIS receipt. And in those 30 days, we get a code with a case number and a receipt number. That's how we log into the consular electronic filing system. With someone who's been living in the United States without legal status, they will have accrued what's called unlawful presence. So you will need a I-601A waiver. That is a waiver for unlawful presence. So it is done before the person leaves the United States. Processing times depend on USCIS, and you can check the website for the most current processing times. In order to get a 601A waiver, you have to prove an extreme hardship to the U.S. citizen. Essentially, it's my U.S. citizen partner or my U.S. citizen parents or legal permanent resident parent cannot live without me, cannot survive without me, and the hardship that they would face or that our family would face is more than the typical family in the United States. To do that, we would need information about economic information, medical information, psychological reports or exams, and even country conditions can be used. We also like to include letters and cards for moral character, and information about the family, so photographs, things that you do together, things like that. The 601A waiver is sent, and the National Visa Center consular process has to be paid for in order to send the waiver. However, you do not finish uploading everything until it's close to the time or after the time that the waiver itself is granted, because it is taking so long that documents can expire. The only things that should be uploaded are things that do not change, such as marriage license, birth certificates, things like that. So if you have any questions, you can call office 626-898-7200. That's 626-898-7200. Thank you so much.